A Treatise on the Law of Notice by William P. Wade. Chapter 2, Part 2, Registration of Instruments. Sections. Registry provided for by statute. Object of American Registry Acts. Registration notice to subsequent purchasers. To effect purchasers must be properly of record. Prerequisite to registration. Subscribing witnesses. When instrument to be filed, consequence of delay in filing, exceptional legislation, English and Irish Registry Acts, equitable mortgage, registry of marriage settlement, Irish Act, registered mortgage and unregistered will, registered legal mortgage and unregistered equitable mortgage, memorandum of further charge, agreement to mortgage, acknowledgement, what instruments should be recorded, reservation of right-of-way, deed of assignment, assignment of lease, assignment of mortgages, consideration, instruments not recordable, assignment for benefit of creditors. Certificate of emancipation, executory contract, same, statute must be complied with, necessity of acknowledgement, certificate of official character required, defective acknowledgments cured by legislation, acknowledgment unnecessary, execution acknowledged by one of two grantors, officers before whom acknowledgment made, lack of uniformity in designating officers, acknowledgment of deed affecting land in another state, justices of the peace, acknowledging officer a party in interest, defects must appear upon the face. Officers de facto, attesting witnesses, when two required, witnessed by one insufficient, defective execution held immaterial, record inoperative without delivery, delivery after recording, same, effect of subsequent delivery, must be recorded by proper officer, recorded by officer de facto, same, effect of error in record, errors in description, effect of filing and subsequent error in recording, to whom is the officer responsible for errors, different construction of the statute, the notice unaffected by errors in recording, partial omission, entire omission, views of early American authorities, 1793, same, 1794, destruction of the records does not affect notice, effect of error in amount secured by mortgage, error in description, fraudulent concealment by officer, immaterial errors, principles governing errors in the record, failure to record in proper time, the index, failure to index does not affect record. Oof. Error in index does not affect record. Failure to index under Iowa statute. Index sufficient to put upon inquiry. Index held partial. Index held part of the record. Grantee cannot control the officer. Mortgagee not affected by officer's failure. Index no part of the record. Same, current of authority. Misleading errors in original. Insufficient description. Errors in numbering. Description of chattels. Description of debt due. Conditions insufficiently expressed. Sufficient certainty. Approximate certainty. Mortgage securing future advances. Description which may be rendered certain by inquiry. Sufficient. Errors not misleading. Immaterial where purchaser not misled. Instruments should be filed for record in their true character. Deed with defeasance is mortgage. Defeasance must be recorded as mortgage. Parole defeasance, deed recorded as mortgage. Sheriff's deed recorded as mortgage, insufficient. Record of secret mortgage must be filed in proper county. Effect of filing in wrong county. Deposit of chattel mortgage in wrong town. Change of county subsequent to filing will not affect registry. Order of priority between deeds. Simultaneous mortgages. As between original parties, priority subject to stipulation. Registration will not divest accrued rights. Innocent purchaser not charged with notice of priorities except by the record. Order of filing governs priority. Deed recorded in reasonable time. Subsequent purchasers alone affected. Record of quit claim. The instrument must be in the chain of title. Same further illustrated. Effect of missing link. Record imparts no notice of relations between parties. Recitals of material facts held not to be notice. Example of broken chain of title. Example of contrary doctrine. The above criticized. Sheriff's deed from apparent stranger. Record of conveyance anterior to grantor's title. Illustration of same. Contrary doctrine criticized. Purchaser from heir without notice of ancestors. Unrecorded deed. Reasons assigned for the rule. Reasons assigned for contrary doctrine. The rule sustained on principle. Review of authorities. Weight of authority and governing principle. Record of conveyances between strangers does not affect purchasers. Effect of record of instruments affecting chattels follows property. Time given for the registration of deeds must be purchaser for value, assignee for benefit of creditors, creditor purchasing at execution sale, purchasers at execution sale notified by registry prior to sale, interest of mortgagee not affected by bidding at execution sale, actual notice of unregistered deed, purchaser protected by good faith of execution creditor, equitable interference in favor of holder of unrecorded title, creditor's interest held to attach from date of levy, unregistered deeds good against creditors with notice. Notice of deed must be subsequent to its execution. Notice of assignment governed by same principle. Judgments given precedence over prior deeds. Deed takes priority if registered before execution sale. Judgments do not become liens after conveyance and before registry. Title not affected by a recording deed after title vests in innocent purchaser. Reasons for the above doctrine. Effect of repurchase by fraudulent grantor. Conflicting decisions as to sufficient notice of unregistered deed. Express notice required. Actual or constructive. Different kinds of notice referred to. Cases holding notice ineffectual against the record. Cases holding implied notice sufficient. Illustration of implied notice. Any kind of notice will affect purchasers. Putting upon inquiry held insufficient. Knowledge of mortgage withheld from record of instrument affecting equitable interest. Effect of withdrawing deed from files before recording. Priority secured by registration. Fraud practiced by agent. Vague information disregarded. Subsequent purchase not invalidated by notice of prior deed. Same doubtful authority. Record chain of title incomplete. The signing of a mortgage regarded as purchaser. Time of notice. Same to attaching creditor. When notice too late. After purchase at execution sale. Before legal title is conveyed. Time of filing for record fixed by statute. Recording after death of grantor, examining records, insufficient inquiry, unrecorded chattel mortgage, description of debt and mortgage. Section 95. Registry provided for by statute. The registry of instruments affecting the title to property being provided for entirely by legislative enactment can only be treated with reference to its effect as notice by giving as near as may be the its indicial construction placed upon the difference. I'm just going to read this sentence over. The registry of instruments affecting the title to property being provided for entirely by legislative enactment can only be treated with reference to its effect as notice by giving as near as may be the initial construction placed upon the different statutes. This could no doubt be more thoroughly accomplished by copying each statute in extenso and then giving the decisions under them. But this course would involve the necessity of extending this treaty to an unwarranted length for the doubtful benefit of presenting a body of statute law which might be undergoing changes while the work was passing through the press. The most that can be safely undertaken in this direction is to present some of the most striking points of difference in the recording acts of the different states of the Union. Those of Great Britain are so essentially different in their scope and administration that for practical work upon a subordinate branch of the law, it could hardly be profitable to compare them in detail with the art of our own legislative bodies. Section 96, Object of American Registry Acts. The general spirit and object of the different American Registry Acts are substantially the same. They are intended to furnish the best and most easily accessible evidence of the titles to real estate, to the end that those desiring to purchase may be fully informed of instruments of prior date, affecting the subject of their contemplated purchases, and also that having availed themselves of this means of knowledge, they may rest there and purchase in absolute security, provided they do so without knowledge, information, or such suggestions from other facts as it would be gross negligence to ignore of some antecedent conveyance or equitable claim. Section 97, Registration Notice to Subsequent Purchasers. It may be stated then, as a rule applicable to all the states, that where an instrument by which the title to real estate is effected is properly recorded, the record thereof is constructive notice to subsequent purchasers or encumbrances under the same grantor. Section 98. To effect, purchasers must be properly of record. But this rule, though applicable to all cases, is not applicable in the same manner, for the reason that the statutes are far from uniform in their provisions as to what is essential in order to render an instrument properly recordable. If not recordable under the law, it could not be treated as properly recorded. Many of them also differ widely from each other in regard to the time from which the record operates as notice. Section 99, Prerequisites to Registration. In a majority of the states, the instrument is entitled to registration when it is properly executed by the party to be bound by its terms and acknowledged before an officer authorized to take acknowledgments. Subscribing witnesses are dispensed with except as a substitute for the acknowledgment before the officer. But in the states of Connecticut, Delaware, Florida, Georgia, Louisiana, Maryland, Michigan, Minnesota, New Hampshire, Ohio, South Carolina, Texas, Vermont, and Wisconsin, the execution is required to be attested by either one or two subscribing witnesses. In the state of Louisiana, the attesting witnesses are required to be males, and where the party is blind, 3 witnesses are required. Section 100, Subscribing Witnesses. The provisions in regard to subscribing witnesses are variously modified in the different states. In some of them, the rule is quite peremptory and governs all conveyances of real estate, while in others, it depends upon where the instrument is executed, whether within or without the limits of the state, the character of the instrument, and other circumstances. In some of them, too, the consequences of a failure to conform to the law with strictness in the matter of attestation are more disastrous than in others, especially with reference to the effect upon their registration. Section 101. When instrument to be filed. In general, the record operates as notice from the date of filing the instrument for record or from the date of its registration, or other formality deemed sufficient to bring the knowledge of its execution and delivery within the reach of anyone who has an interest in making inquiry. But in several of the states, the statutes prescribe certain periods of time within which the instrument shall be deposited with the designated officer for record. These periods vary in the different states as follows. In Alabama, 3 months, Delaware, 1 year, District of Columbia, 6 months, Florida, 6 months, Georgia, 1 year, Indiana, 45 days, Kentucky, 60 days. When executed and acknowledged within the state, and 4 months in cases of non resident grantors, Maryland, 6 months, New Jersey, 15 days, Ohio, 6 months, Oregon, 5 days, Pennsylvania, when within the state, 6 months, when the deed is executed without the state, 1 year, South Carolina, 30 days, Virginia, within 60 days after delivery of the instrument. Section 102. Consequence of delay in filing. These provisions are not ordinarily construed as fixing periods of limitation, but rather as giving the grantee so much time as days of grace within which their instruments may be registered without incurring the danger of being cut out by conveyances from the same grantor during the intermediate time. Section 103. Exceptional legislation. Exceptional acts of legislative bodies of the states may provide for the filing of such instruments in a manner to give purchasers the substantial benefits of registration without affecting them with constructive notice. As the law enacted by the legislation of the state of New York, January 8, 1794, the object of this act was to settle conflicting claims to bounty lands in that state. It provided that all deeds and conveyances thereto executed of or concerning such lands, or whereby they might be affected at law or in equity, should, on or before a day named, be deposited with the clerk of the city of Alabama, and all such except mortgages duly registered, not so deposited, should be adjudged fraudulent and void as against subsequent purchasers or mortgagees for a valuable consideration. It was made the duty of the clerk to keep these instruments arranged in alphabetical order, to the end that persons inclining to have recourse thereto may inspect the same, paying the usual fees for search and inspection. A subsequent portion of the same act provided for the registry of deeds thereafter executed, but it was held that compliance with the first provision of the act would not charge subsequent purchasers with constructive notice of the instruments deposited with the clerk. Section 104. English and Irish Registry Acts. Under some of the English and Irish Registry Acts, it has been decided that the registry of an instrument does not itself operate as constructive notice to subsequent purchasers. Section 105. Equitable mortgage. So where a mortgage had been duly registered and S subsequently received the title deeds on deposit as security for debt owing by the mortgagor without actual notice of the prior registered mortgage, it was held that the possession of such title deeds was available in his hands as an equitable mortgage upon the premises, notwithstanding the formal registry of the prior mortgage. Section 106. Registry of Marriage Settlement. So also where the law provided for the registry of marriage settlements, it was held in the case of Hodgson v. Dean that a subsequent purchaser of the land included in such settlement could only be effected by actual notice. It was decided that the defendant was not bound to search the register and therefore could not be constructively notified of its contents. Section 107 Irish Act. The Irish Registry Act, under which the case of Bushell v. Bushell was decided after providing for the registry of deeds and conveyances, declared that every such deed or conveyance, a memorial whereof, shall be duly registered, according to the rules and directions in this act prescribed, shall be deemed as taken as good and effectual, both in law and equity, according to the priority of time of registering such memorial for and concerning the honors, manners, etc., and such deed or conveyance mentioned, and contained according to the right, title, and interest of the person so conveying, etc., against all and every other deed. conveyance or disposition of the honors, etc., or any part thereof comprised or contained in any such memorial as aforesaid. Still, this was not deemed sufficient to constitute such registry constructive notice to subsequent purchasers of the property included in the memorial, and he would not be bound except by actual notice. Section 108, Registered Mortgage and Unregistered Will. A more recent case arising under the Registry Act for the East Riding of Yorkshire seems to present a view of the law somewhat more favorable to the tenant whose evidence of title is registered than is accorded to him in the earlier English cases cited. It is decided that a mortgagee whose mortgage has been duly registered shall prevail against a devisee in an unregistered will which was discovered subsequent to the registration of the mortgage given by the heir and after the time within which the Registry Act required wills to be registered in order to be valid against conveyances from the heir. The statute also provides that where there is an impediment to the registration of the will within the time that the registration of a memorial such as impediment will preserve the rights of devisees as though the will itself had been registered, until such time as the impediment is removed. It was held in the case cited that the failure to discover the will was such an impediment as was contemplated by the Act, and because the devisees who were ignorant of their interests in the premises did not deposit for registration a memorial of the impediment to the registration of the subsequently discovered will, that instrument was void as against the subsequent mortgagee without notice. Section 109, Registered Legal Mortgage and Unregistered Equitable Mortgage. So under the Registry Act for Ireland, in a recent case where the owner of an estate had created an unregistered equitable mortgage upon his estate by the deposit of the title deeds, such equitable mortgage was postponed to a subsequent registered legal mortgage, and it was further held that such legal mortgage could not be successfully assailed upon the ground that the solicitor employed to draw the same accepted a frivolous excuse for the absence of the title deeds and drew the mortgage from memoranda of the contents of the deeds furnished by the mortgagor. It was held to be inconsistent with the policy of the Irish registry law to impose on a mortgagee or purchaser the duty of inquiry with a view to the discovery of previous unregistered interests. Section 110, Memorandum of Further Charge. So, also, where a mortgage was given on lands in Yorkshire and was duly registered under the Act, and a subsequent memorandum of further charge on the same property in favor of the mortgagee for additional advances was made, although no amount was mentioned in the mortgage, the memorandum was deemed a proper instrument for registry, and not being registered was postponed to a subsequent registered mortgage in favor of a mortgagee without notice of the further charge. Section 111, Agreement to Mortgage. An unregistered agreement to give a mortgage on lands in a registered country was held pursuant to the Registry Act to be a proper subject for registration, and was accordingly postponed to a subsequent registered mortgage taken without notice of the unregistered agreement. Section 112, Acknowledgement. The recording acts of the states of this union uniformly require instruments offered for record to be duly acknowledged before an officer authorized by law to take acknowledgments, and though the officers designated by law to receive such instruments for record have no judicial authority to determine whether they are legally entitled to registry, and consequently receive and file such as are offered, regardless of legal defects in their execution or acknowledgement, yet a failure to comply with these formal prerequisites on the part of a grantee generally has the effect to invalidate the record as constructive notice to subsequent purchasers. It is not sufficient that the genuineness of the signature or even the fact that the execution was properly acknowledged can be established by evidence. All this must appear in the official certificate attached to the instrument and be spread upon the records in order that the record shall operate as constructive notice. Section 113. What instruments should be recorded? In construing some of the registry acts of the states of the Union, it has been held that only instruments by which the legal title to the premises was conveyed were entitled to registration. But the prevailing rule now is that any instrument by which an equitable interest in the property is effected, or a right arising out of the property is granted or reserved, should be recorded. And if executed with all the formalities prescribed by law, the record will be constructive notice to subsequent purchasers or encumbrancers to the same extent as the record of a conveyance of the legal title. Section 114. Reservation of right of way. So, where a right of way was by agreement reserved out of land conveyed by a deed in which no mention of the reservation was made, it was held that an innocent purchaser, for valuable consideration from the grantee, was not charged with notice of such reservation because the same had not been reduced to writing and filed for record, as was required of instruments affecting the title to the land itself. The same rule would hold good of other easements either granted or reserved. Section 115. Deed of assignment. It has also been held that a deed of assignment in trust for the benefit of creditors may be recorded, and in the absence of fraud, such record would be sufficient notice to the creditors affected by the conveyance. Section 116. Assignment of lease. So where a lease of real estate is transferred by a separate instrument, such instrument, being a transfer of an interest in land, is properly recordable. And when the statute is complied with in respect to the acknowledgement and other prerequisites, and the description is sufficiently certain to identify the premises as those contained in the lease, the record will operate as notice to subsequent purchasers. Section 117. Assignment of mortgage. And where the statute declared that assignments of mortgages may be recorded without special provision for the record of such assignments operating as notice, although the language was mandatory as to such records being received in evidence, it was decided that such records would be noticed to subsequent purchasers or assignees, the same as though the provisions of the statute had been imperative in requiring the registry of assignments. Section 118. Consideration. The fact that such a deed is without consideration or has only such consideration as at common law is called good, as distinguished from valuable, does not disentitle it to registry. And being recorded after all the requisite formalities have been complied with, the record operates as notice, as though the conveyance were for a valuable consideration. Of deeds of this class, those from husband to wife are instances, and the record of such deeds has been held to stand upon the same footing as to notice as the record of any other conveyance. Section 119. Instruments not recordable. But an instrument which is not required to be recorded, nor even mentioned in the statutes among those which may be recorded, would not be regarded as one contemplated by the legislature as a recordable instrument. Consequently, should it be copied upon the records, such copy would not amount to constructive notice to anyone. Section 120. Assignment for benefit of creditors. So where a deed of assignment for the benefit of creditors was not required by law to be recorded, the record of such deed was held not to be noticed to those who might purchase in ignorance thereof. Section 121, Certificate of Emancipation. So also was it held that a certificate of emancipation was an instrument not required to be recorded nor entitled to record. And the same was held regarding a deed to a slave, though it was decided that the recording of such deed was sufficient to rebut the idea of concealment, and might be offered in evidence as a circumstance tending to prove actual notice. Section 122, Executory Contract. An executory contract, except where its registry is provided for by law, would gain nothing by being recorded. Such record would not be notice of the existence of such contract to any persons except those who actually saw the same. Section 123, same, and even where the New York statute made provision for the registry of such contracts, it was held that the record did not constructively impart notice to anyone, because the statute providing for the registry was merely to preserve the evidence of the contract and not to give notice of its existence. Section 124, statute must be complied with. The requirements of the statute, both in regard to the official character of the acknowledging officer and the contents of his certificate, must be complied with in every substantial particular, or the record of the instrument will be inoperative as constructive notice. Section 125, necessity of acknowledgement. In many instances, this construction of the statute has seemed to work hardships upon those who had purchased upon the faith of the record title. But not only is the construction given to the statute by the courts strictly defensible, but the statutory provision itself is dictated by the highest considerations of security to owners of real estate. Were it not for this check upon human cupidity, the records might be cumbered with fraudulent conveyances from suppositions grantors. Supposititious. Nope. Suppositions. Grantors. Which, while they failed to clothe the grantees with even a shadow of title, would suffice to be cloud the titles of those who were purchasers from the true owners, as to frighten timid purchasers and depreciate the value of property. So too is this wise provision a wholesome restraint upon forgery. The commission of this crime is rendered less easy and safe when, to make it effective, it becomes necessary for the forger to take a public officer into his confidence. Section 126, Certificate of Official Character required. Following this principle of construction of a statute requiring the certificate of a clerk of a court of record, where the acknowledgement was before a notary public in another state, to the genuineness of the notary's seal and certificate, it was held that a deed acknowledged beyond the limits of the state before a notary, whose official character, etc., was not so certified, was improperly admitted to record and did not operate as constructive notice. Section 127, Defective Acknowledgements cured by legislation. In some of the states, however, legislation has come to the relief of defectively acknowledged instruments. The general tenor of these curative acts is that from the taking effect of the statute, all instruments previously recorded, defectively acknowledged or attested, or not acknowledged and attested at all, should operate as constructive notice to purchasers to the same extent as though they had been properly acknowledged. Notwithstanding the apparent retrospective operation of statutes of this kind, they have uniformly been approved by the courts and sustained as constitutional. Section 128, Acknowledgement Unnecessary. Under statutes which may fairly be regarded as exceptional, the record of a deed has been held to operate as constructive notice to subsequent purchasers, though it effectively acknowledged, and where the statute provided that no instrument affecting real estate should be of any validity against subsequent purchasers for valuable consideration without notice, unless recorded, and that where a deed had been acknowledged and certified in the manner prescribed by law, the original might be read in evidence without further proof of the execution. It was held that, as the statute was silent as to the matter of acknowledgment, as a prerequisite to the registry of the deed, and only required this formality as a condition to its being read in evidence without proof of execution. A deed in fact registered, even though it were not acknowledged, would be constructive notice to subsequent grantees who purchased for value and without actual notice. Section 129. Execution acknowledged by one of two grantors. And even in a case where the statute required the instrument to be acknowledged to render its registry effective as notice to subsequent purchasers, it was held that an acknowledgment by one of two grantors met all the requirements of the statute so as to render the record of the deed not only constructive notice of the conveyance of the interest of the grantor who acknowledged the deed, but also the interest of the one who failed to acknowledge. The reasoning in this case was that the object of the statute being to give publicity to conveyances that object was attained whenever the deed was placed upon record, and it could not have been recorded without authority, because when it was acknowledged by one, its registry was authorized as to him, and it was quite clear that his conveyance could not be recorded without recording that of the other grantor. Section 130. Officers before whom acknowledgment made. The officers empowered to certify to the acknowledgment of instruments for record, as designated by the recording acts of the various states, are numerous and diverse in their characters, but perhaps the most universally recognized, as well as the most generally resorted to, are notaries public. In addition to these are judges, including justices of the Supreme Court of the United States and of the different states and territories, county and probate judges, and nearly all judicial officers of intermediate degree. Another class that is quite generally recognized are justices of the peace. These, as well as most other officers who do not use a seal to authenticate their official acts, are less frequently employed for the reason that it is generally necessary, when the instrument affects property in another state, to fortify their certification of the acknowledgment by the certificate of the clerk of a court of record that such officer had been commissioned and qualified, and that his signature is genuine. Besides those already mentioned are chancellors, clerks, mayors, masters in chancery, court commissioners, prothonotarians, foreign ministers, consuls, and other diplomatic officers and commissioners, especially appointed for that purpose by governors of different states. Even surveyors and army officers of the rank of major or higher rank have been designated in some instances. Section 131. Lack of uniformity in designating officers. It may not be out of place to remark here that much of the apparent harshness in the operation of the recording acts arises from mistake in selecting the officers before whom acknowledgments are made. These misfortunes are owing to a want of uniformity in the statutes of the different states, and it is no consolation, but rather an aggravation to reflect that the diversities have no better foundation than local caprice. Section 132. Acknowledgement of deed affecting land in another state. When the instrument executed in one state affects the title to land in another, the law of the state where the land lies, of course, will govern, and not that of the place where the instrument is executed and acknowledged. As the validity of the record depends in no small degree upon the officer whose certificate authenticates the acknowledgement, the selection of the proper one becomes a matter of importance. Section 133. Justices of the Peace. It has been held under a statute limiting the jurisdiction of justices of the peace to taking the acknowledgments of such instruments as affected lands lying within their own counties, that where the acknowledgment was taken before a justice to a deed of land in another county, the record of such deed failed to impart constructive notice. Section 134. Acknowledging officer a party in interest. So also, when there is any circumstance that disqualifies the officer from acting in the particular instance, the record will be vitiated, and when on the face of the deed it appeared that the acknowledgment was before a party in interest, it was held to be improperly recorded, and that the record did not impart constructive notice to subsequent purchasers. Section 135. Defects must appear upon the face. It would be otherwise, however, where the instrument was fair upon its face, as the record will impart notice, notwithstanding hidden defects in the execution or acknowledgment. Section 136. Officer de facto. But where the acknowledgment is certified by an officer de facto, though he be a usurper of the office, if the jurisdiction extends to the taking of acknowledgments, the instrument will be properly recorded, and the record will be as effective as though it had been acknowledged before an officer de jure. Any subsequent proceeding by which the usurpation of the office might be established would not affect the validity of his official acts regularly performed. Section 137. Attesting witnesses. In a majority of the states of the Union, the certificate of acknowledgment is all the authentication required to admit the instrument to record. It is only in the absence of such certificate that the execution is required to be proved by attesting witnesses, as a substitute for the more convenient method of acknowledgment before an officer. But in some of the states, as we have seen, the attestation of witnesses is required in addition to the formal acknowledgments, and in some of these instruments, copied upon the records without being so attested, have been held not to impart constructive notice by virtue of their registry. Section 138. When two required. As where the execution of a deed was required by statute to be attested by two subscribing witnesses, and one of the names subscribed thereto was that of the wife of the party executing it as grantor, this defect was held to be of so substantial a nature that an instrument so witnessed was not a deed, and not entitled to be recorded. Consequently, the record would not operate as constructive notice. Section 139. Witnessed by one insufficient. So when a mortgage required by statute to be attested by two witnesses, in addition to the acknowledgement, though regular in every other respect, was executed in the presence of and attested by but one witness, this was held to be a substantial defect in the execution of the instrument, by reason of which it was not recordable, and the unauthorized record thereof would not affect subsequent purchasers or encumbrances. Section 140. Defective execution held immaterial, but the authorities are not uniform in exacting strict compliance with legal requirements in the execution of the instrument as a condition precedent to its admission to the records. Where equitable interests are recognized as the proper subjects of registration, the record of any instrument which passes the equity would be good constructive notice of that interest and would be as conclusive upon subsequent purchasers as though the legal title had passed to the grantee. In pursuance of this doctrine, where a seal was recognized as one of the essentials of a deed to real estate, an acknowledgment was the only legal formality prescribed for the admission of the public records of instruments whereby legal or equitable titles or interests in real estate were affected. It was held that a deed of conveyance from which the seal was omitted passed an equitable interest to the grantee, and being duly acknowledged was properly recorded, and the same effect was to be given to the record of this unsealed deed as it would have been entitled to had it been sealed. It was constructive notice to all subsequent purchasers. Section 141, Record inoperative without delivery. A further prerequisite to a valid registry is that the instrument be delivered before recorded. Therefore, the deed should not be deposited for record until after delivery. The obvious reason of this rule is that until delivery, the deed is incomplete. It was not intended that instruments affecting the title to real estate, which were by law required to be recorded, should operate as constructive notice of a change of ownership in the property, which they were utterly powerless to effect. A deed without delivery is as inoperative as though it had never been executed, and may be of even less effect than it would be with a defective execution. Section 142. Delivery after recording. Where a deed was executed and acknowledged by the grantor, who, of his own motion, filed it for record, and after it had been duly copied upon the records, delivered it to the grantee, the record was held not to impart notice from the date of filing, for the reason that, until delivered, it was not a completed instrument, as the title to the property was still in the grantor. Section 143, same, effect of subsequent delivery. Where, however, the deed is delivered after it has been recorded, it does not lose all the benefits of the registration, but the record will be notice to all who purchase subsequent to the delivery. But those who may have purchased during the time between the registration and the delivery of the deed without notice and for value will be as effectually protected as though the instrument had never been recorded at all. Section 144 must be recorded by proper officer. It would seem scarcely necessary to add that in order to render the recording effectual, it should be the act of an officer duly authorized and empowered to act in the premises. The mere copying an instrument upon the records by a volunteer who had not been previously deputized or authorized to perform the work would not amount to constructive notice. Section 145, recorded by officer de facto. But where an officer is acting under a government de facto, though it be unlawful and revolutionary, if it be of paramount force within the district where the officer exercises his functions, his official acts not directly in aid of the war power of the unlawful government will be regarded as valid and binding. Section 146, same. So the registry of a deed by a clerk who continue to exercise his official duties in the state of Virginia after the passage of the Ordinance of Succession, while the county was under control of the military power, was held valid. Section 147. Let's see. Huh. Section 147, effect of error in record. The record, in order to fulfill its proper function, should be an exact copy of the words and figures contained in the original, set forth in their proper order of arrangement. The greatest care is usually taken in recording to produce a literal transcript of the instrument filed for record, even to the perpetuation of its errors and omissions. But in prosecuting his labors with the exact nicety required to avoid trifling errors, the officer occasionally commits errors of a graver sort by which the record is liable to mislead. The errors of this kind have been held to vitiate the record and destroy its efficiency as constructive notice. Section 148, errors in description. As where the statute rendered the filing of the instrument constructive notice to all purchasers subsequent to the date of such filing, regardless of the time of copying the instrument upon the records, it was held that after the record was completed, purchasers without actual notice of the contents of the original had only constructive notice of what such record would disclose, and there being an error in the description, by which it appeared that the interest conveyed was the undivided interest, whereas in the original deed it was the individual interest, it was held that the notice was only of the conveyance of the undivided half, as appeared by the records. So where the recorder inserted the name of the wrong person as grantor, the record was treated as notice of a conveyance by the individual whose name was erroneously entered upon the records as executing the instrument. Section 149, effect of filing and subsequent error in recording. Many of the recent authorities seem to favor the view that when the instruments have been spread upon the records, they only give notice of the contents of such as are correctly recorded, although previous to their being recorded. The filing for record is complete notice of the contents of the original. The purchaser is protected in placing complete reliance upon the records as he finds them, and is not bound to take notice of errors in recording of which he has never been actually informed. This doctrine is fully maintained and ably set forth in the case of Terrell v. Andrew County by Judge Wagner, who, in delivering the opinion of the court, says, "The obligation of giving the notice rests upon the party holding the title. If his duty is imperfectly performed, the consequences must fall upon him and not an innocent purchaser. In this case, the filing is recognized as sufficient to protect the grantee, even where the deed has not been recorded. In examining titles, one first searches the records and then examines the files in case he finds nothing recorded. But if the record shows a conveyance, he will be guided by that and will not consult the files in order to examine the original. It is held that the bond given by the recorder for the faithful performance of his duties is for the benefit of every person injured by his dereliction of duty, and not merely for the benefit of subsequent purchasers. In this case, for the one who deposited the deeds and paid for having them recorded, according to the views of the learned judge, it would seem to be incumbent upon the grantee to supervise the work of the officer, or at least to examine the record when completed and compare it with the original. The officer seems to act in the capacity of agent of the grantee. Section 150. To whom is the officer responsible for errors? If this were a purely speculative question, and not one which must be determined by the weight of authority, one might be led to inquire why it is that for such acts of nonfeasance or misfeasance, these officers are not always required to answer to the same class of persons. As will presently appear, the innocent purchaser is in some instances regarded as the one whose rights are prejudiced by acts of negligence, somewhat similar to those treated of in the opinion above, and the record remains unquestioned. Section 151. Different construction of the statute. The case of Terrell v. Andrew County may be regarded as settling the law upon this question for the state within whose jurisdiction it was decided, but the principles upon which the decision is based not only may be questioned, but confronted by a very respectable array of authorities expressing opposite views. Section 152. The notice unaffected by errors in recording. In a case where the records had been mutilated and partially destroyed, Reese J., who delivered the opinion of the court in commenting upon the doubts raised as to whether the deed had been properly recorded in the first instance, says, but assuming that the deed was not properly recorded in the first instance, we then say that it is sufficient that the deed was left for record by the grantee. Section 153. Partial omission. So in another case arising in the same state, it was held that when the deed is left with the officer, the grantee has done all he is required to do, and his rights will be protected, though the recorder records only a part of the deed. Section 154. Entire omission. So also was it held in the case of Throckmorton v. Price, that a grantor leaving his deed for record is not bound to see that it is recorded. His filing, it is regarded as equivalent to its registration, so far as he is concerned, and his rights will be protected though it be not recorded at all. Section 155. Views of early American authorities, 1793. That there is no novelty in this view of the law will appear by consulting the earlier American authorities. In the case of Franklin v. Cannon, decided in Connecticut as early as 1793, it was held where a deed had remained for a long time in the office of the clerk without being recorded, through no fault of the grantee, that he should not be prejudiced by the negligence of the officer, but the deed should be regarded as recorded from the time it was left with the officer for that purpose. Section 156, same, 1794. In another case, a mortgage was delivered to the clerk for registry on June 26, 1766, and after an endorsement was made thereon to the effect that it was then duly registered, it was returned to the mortgagee. Subsequently, in the year 1771, the land was conveyed by the mortgagor to another, and the deed was recorded the same year. The land was conveyed by deed to still another purchaser without notice in 1772, and the deed recorded immediately, the purchaser going into possession in 1773. The mortgage was not actually copied upon the records until as late as 1794. Yet in an action of ejectment by the mortgagee, he was held to be entitled to the possession, as he was not at fault in the matter of registration. The deposit of the mortgage with the clerk was all the duty which the law imposed upon him, and all subsequent purchasers were thereby constructively notified of the encumbrance. Section 157. Destruction of the records does not affect notice. It has also been decided that where the deed has been once recorded, a subsequent burning or other destruction of the records will not render the same ineffectual as notice to subsequent purchasers. This latter position will hardly be disputed, yet it is supported by the same reasoning as that urged in defense of the constructive notice of a deed properly deposited for record and omitted or improperly transcribed by a negligent officer. Section 158. Effect of error in amount secured by mortgage. Upon the other hand, it was decided where a clerk in recording a mortgage committed an error in transcribing the amount secured and rendered it $300 instead of $3,000, that the record was only notice of the amount therein expressed. Section 159. Error in description. So where in recording a conveyance of the east half of a tract of land was recorded by mistake as the west half, the error was held to vitiate the record. Section 160. Fraudulent concealment by officer. And even where the officer designedly and for the purpose of concealment and fraud copied a deed deposited with him for record into a book which was no longer used as a record of titles, the deed was held not to be recorded and failed to impart notice constructively. Section 161. Immaterial errors. But mere clerical errors, such as a mistake of a letter in the name of a trustee in an assignment, or when the assignment is stated to be to one person and the habendum is to another, it will certainly not rob the record of its character as constructive notice. So where there is enough upon the record to put a prudent man upon inquiry, it has generally been held sufficient to amount to constructive notice, although the property is misdescribed in the record. Section 162. Principle governing errors in the record. In order to arrive at a correct conclusion upon principle in regard to the conflicting rights of prior and subsequent purchasers as affected by the registry laws, one of the most pertinent inquiries is, for whose benefit was the statute enacted? Or, in other words, whom does it protect, and upon whom does it impose additional burdens? A brief glance at the common law status of the parties will answer these questions at once. The prior grantee was secure without the aid of the statute, where the subsequent purchaser knew of the existence of his deed or not. The intended purchaser had the most imperfect means of ascertaining the condition of the title. The statute was interposed for the purpose of furnishing him with the necessary information, and in doing so, it was found necessary to impose an additional obligation on the first grantee. If, then, the law is primarily for the protection of the subsequent purchaser, it would seem that any breach of duty by the officer was a violation of his rights in the premises, and the delinquent official should be required to answer to him. The conclusion seems to follow inevitably that from the deposit of the instrument with the proper officer for record, it should be regarded as constructive notice to all persons who subsequently deal with the title, notwithstanding any errors by the officer in recording the instrument, or even when he neglects to record it at all. Section 163. Failure to record in proper time. So where a time is fixed by law within which an instrument is required to be recorded in order to operate as notice to subsequent purchasers, and the officer, through press of business, negligence, or dishonest motives, fails to record it within such time, his failure will not be allowed to work prejudice to the interests of the party who is interested in maintaining the validity of the record when the instrument has been deposited with the recorder within the statutory period. Section 164, the index. There are other errors committed by the recording officers, scarcely less misleading in their character or disastrous in their operation, than mistakes or omissions in copying the instruments filed for record. The index to the record is of such importance that, without it, the cost of employing a competent person to examine the records would, in some instances, equal, if not exceed, the value of the property to be conveyed. These are, in some cases, held to be essential parts of the records, in the absence of which subsequent purchasers would not be charged with notice. In this case, it was so held, though the question was not essential and had nothing to do with a determination of the controversy, as the purchaser was charged with actual notice of the recorded but non-indexed mortgage. The question was also discussed in Shelby Stein, but no decisive conclusion arrived at, for the reason that, in that case, the deed was properly entered, as the statute required, in the index to the volume in which it was recorded, but was omitted from the general index kept by the recording officer, for which, however, the law made no provision. In this case, the court regarded the officer as resting under an obligation to furnish the necessary information to searchers of the records, and if he voluntarily provided a general index upon the correctness of which they were induced to rely, he was liable to such as were misled by failure to make entries therein according to his usual custom. Section 165. Failure to index does not affect record. Where, however, the question has come up directly for decision, it has been held in the majority of cases that the failure to index is an act of misprision, for which the officer is liable to the searcher of the records, who is thereby misled to his injury. The grounds upon which this is placed is a recent case seem very reasonable. It is claimed that the ease with which what is on the records may be found is not a matter which concerns the owner of the deed, but rather the searcher of the records. The index is made for the benefit of the public, who may desire to use it for the purpose of investigating the condition of titles to property, and not for the benefit of the owners of the property, who know that they have done all that the law requires of them in filling their evidence of title for record. Section 166. Error in index does not affect record. A case decided under the Iowa statute presents some striking, if not perplexing, features. The statute provides for indexing all instruments, filed such index to show the names of grantors and grantees, the time of filing, the date of the instrument, its character, and the book and page where the record may be found. The entries in the index, with the exception of the page, are completed before the instrument is required to be recorded in extenso. The views expressed by Judge Dillon in delivering the opinion of the court in this case are not in entire accord with the authorities hereinbefore cited, but the statute is peculiar in respect to the feature of indexing. Compliance with its requirements in this particular renders the entries made constructive notice to all the world of the rights of the grantee conferred by such instrument, and the instrument may be copied into the records as soon as practicable, after which the index entries are completed by inserting the number of the page upon which the instrument is recorded. In this instance, the recording officer discharged his duties without substantial error or omission until he came to the final act required in order to complete the performance of his functions in connection with this particular deed. He entered the wrong page of the record opposite his entries in the index, so that instead of directing the attention of the examiner of the records to the page where the instrument briefly described in the alphabetical index was copied at length, he was referred to a different page where another deed was recorded from the same grantor, but to a different grantee. This was held sufficient to put a purchaser upon inquiry, and by the dissimilarity between the names of parties as they appeared in the index and on the page referred to, suggest an error which would have been fully disclosed by a more careful search. Section 167. Failure to index under Iowa statute. This would seem to be a stronger case in support of the validity of records as constructive notice, regardless of the index, than that of Chatham v. Bradford, were it not for the reasoning by which it is supported. If an index misleading on account of a palpable error might not vitiate the record, it could be claimed, with a fair show of reason, that a perfect record with no index would be valid. But this court earlier in the same term decided that a failure to index rendered the record void as to subsequent purchasers without actual notice. This too, under an earlier statute which had not the same provisions as to indexing. The portion prescribing the manner of indexing was not as it was in the latter statute, preceded by the statement that no instrument affecting real estate should be of any validity against subsequent purchasers, etc., unless recorded in the office of the recorder of deeds in the county in which the land lies, as hereinafter proceeded. The earlier statute provided. The earlier statute also contained a provision that instruments required to be recorded should, from the time of filing the same with the recorder, impart notice to all persons of the contents thereof. The court, however, in the case last cited, held, as in the case of Terrell v. Andrew County, that the notice by filing was only temporary and ceased when the instrument had been spread upon the records, and a failure to index rendered the record worthless. In so deciding, the eminent judge who delivered the opinion in both the Iowa cases followed the authorities in that state, and has in turn been followed by others to the same effect. Section 168. Index sufficient to put upon inquiry. Where, however, the requirements of the statute have been complied with in every substantial particular, a mere omission by the recording officer to make any of the entries in his index which the act prescribes, where such omissions leaves enough to direct the attention of one who examines the index to the proper book and page, or is even sufficient to put a cautious or prudent man upon inquiry, the records will not be thereby rendered void as notice to purchasers, as where the description was omitted and instead thereof the recorder inserted the words "see records." This was held not to be misleading and hence did not vitiate the records. So too, where instead of the description were the words "certain lots of land," the courts held this sufficient to put a purchaser upon inquiry and hence to charge him with notice constructively. Section 169. Index held part of the record. In a case decided under a statute clothing the index with the character of notice to subsequent purchasers, it was held to be a record by which they were charged with constructive notice, even when there was a substantial error in the record itself. Section 170. Grantee cannot control the officer. It seems the more reasonable doctrine that the neglect of clerical duties by the officer should not be chargeable to the grantee or mortgagee, who, in depositing the instrument for record, does so in obedience to the mandate of the law. The doctrine of respondeat superior cannot apply as though the officer were the private agent or servant of the party whose deed is deposited. He is not chosen by the party depositing. Wait a minute. Where's my microphone? Oh, 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 goodness gracious. All right. Oh, goodness gracious. Okie dokie. That's a highlight here. Huh. The doctrine of respondeat superior cannot apply as though the officer were the private agent or servant of the party whose deed is deposited. He is not chosen by the party depositing the instrument to perform the duties of filing, recording, and indexing, but is designated by the law as the proper officer, and the grantee or mortgagee is compelled to apply to him and none other, and having done so, has no control whatever over his action. Section 171. Mortgagee not affected by officer's failure. It has therefore been justly held, where the law made it incumbent upon the county clerk to number mortgages of chattels when deposited for record, that his failure to perform this duty in any instance should not impair the rights of the mortgagee, however much subsequent purchasers might be misled to their injury by the omission. Section 172. Index no part of the record. So also where the statute required the clerk to make an index of the records, it was held that this duty was prescribed for the purpose of furnishing facilities for those interested in searching the records, and that the index being no part of the records themselves, it was not essential that the instrument should be indexed in order to become constructive notice to subsequent parties. Section 173, same, current of authority. The fact that questions of this kind are decided by courts with different and independent jurisdiction, each construing its own statutes, may account to some extent for the diversity of opinion upon the importance of indexing the records, but the difference is too marked and decided to be altogether accounted for in this manner. It will be noticed that in neighboring states having registry laws with substantially the same provisions in this respect, the statutes have received opposite constructions. But the current of authority seems to be decidedly against the doctrine that the index is an essential part of the record. Section 174, misleading errors in original. There are errors, mistakes, omissions, and ambiguities, such as are calculated to mislead an examiner of the records, for which the recording officer is in no way responsible. This is when the fault lies in the original. In such cases, if the discrepancy is of a substantial nature, the record is vitiated, as where the property intended to be conveyed was the east half of a lot and was described in the deed as the west half, the record failed to give notice of the conveyance of the property intended. Section 175. Insufficient description. Also where a transfer of a lease of real estate was made by a separate instrument, which being a transfer of an interest in land, was entitled to be recorded, it was held that in order to operate as constructive notice to subsequent purchasers, it should contain such a description, not only of the premises, but of the term, that the original lease could be recognized as the thing transferred. Section 176, errors in numbering. The purchaser at an execution sale of land previously conveyed by a deed in which the land is so indefinitely described or erroneously numbered that it cannot be identified or is likely to be mistaken for another tract, is not affected by the record of such prior deed with notice of what was intended to be thereby conveyed. Section 177, description of chattels. The record of a mortgage of chattels, in order to operate as notice to subsequent purchasers, must contain such a description of the things included in the mortgage as to enable one examining the records to identify the property, as where cows were mortgaged and left in possession of the mortgagor, their calves brought forth after the execution of the mortgage would not be included therein unless mentioned. Section 178, description of debt due. So, where the instrument was a mortgage and the description of the debt secured was a debt due from the mortgagor to the mortgagee, by note dated 10th of May, 1834, on demand with interest, without specifying the amount, it was held not to be noticed to subsequent purchasers of a valid security for the reason that the spirit of the Recording Acts requires the record to disclose with as much certainty as possible the state of the encumbrances upon the property. Section 179, conditions insufficiently expressed. So also where the condition of the mortgage was that the mortgagor should pay all notes endorsed by the mortgagee for the mortgagor and all receipts held by the mortgagee against the mortgagor. The record of such mortgage was held void as against creditors of the mortgagor. Section 180, sufficient certainty. On the other hand, where the mortgage describes the debt secured with such particularity that there could be no difficulty in determining by inquiry what debts were and what were not embraced in the description, the maxim, that is certain which may be made certain. That is certain which may be made certain will be applied. It has accordingly been held not to be requisite that the condition should be so completely certain as to preclude the necessity of extraneous inquiry. Section 181, approximate certainty, and where the debt secured was described in the defeasance clause as follows: if I shall well and truly pay to be, on demand with interest, the sum of $1,500, which I am indebted to him on book and by several notes, the exact date and amount not recollected, but amounting in the whole together with the debt on book to the sum of $1,500 or thereabouts, then this deed shall be void. And it appearing that when the mortgage was given, the mortgagor was in failing circumstances and had not time to ascertain the precise amount to be secured, which was in reality in excess of $1,500, the mortgage was held valid as against other creditors and subsequent encumbrances, and the record operated as notice to them to the extent of the amount mentioned therein. Section 182, mortgage securing future advances. It has also been held that the record of a mortgage is not intended as notice of the amount due thereon, and is valid when future advances are secured, without specifying the amount with particularity. Section 183, description which may be rendered certain by inquiry sufficient. In order that the record of a deed shall be vitiated by errors or uncertainty in the description or other part of the original, the error must be in a matter of substance, or the uncertainty one which cannot be rendered certain by such inquiries as the record would naturally excite. So where there was a contract to convey, in which the property was described as so many acres of my land, which I hold in the South Mountain, anywhere on the Turnpike Road, between Newman's and the bridge over the Canada de Quinque Creek, it was held that this gave the covenantee a right of selection within the prescribed limits, and the record of the instrument was constructive notice of that right. Section 184, errors not misleading. So also where in a deed the number of the town and range were transposed so that there was no such piece of land in the county as described in the deed, it was held that the record of the deed disclosed enough to put a prudent man upon inquiry, and as such was sufficient notice to subsequent purchasers of the land actually intended to be conveyed. Section 185, immaterial where purchaser not misled. The error in the deed, in order to vitiate the record thereof, must be one of must be one calculated to mislead the purchaser. Therefore, if the purchaser had any knowledge of the error or from his knowledge of the property and its surroundings would have been able to interpret the record and give it the meaning it was supposed and intended to convey, it would be sufficient to charge him with notice, as where a mistake in the record was discovered by the attorney of the subsequent purchaser, such mistake being in the description, west instead of north, the fact that this was easily recognized by the attorney of purchaser while engaged in examining the records for his principal manifested such a knowledge of the property and its situation that the mistake would not vitiate the record. Section 186. Instruments should be filed for record in their true character. Another important requirement in regard to the registry of instruments in order that they may operate as constructive notice is that they should be registered in their true characters. Otherwise, they may fail to give notice not only of the estate or interest they are intended to affect, but of that which they are on their face purport to convey. As where an instrument is drawn and executed in the form of an absolute deed, which is intended only to take effect as a mortgage, it should be registered as a mortgage and not as an absolute deed. The reason of this is that the instrument not being an absolute conveyance of the property, its registry as such cannot charge anyone with notice of its contents. It being in reality a mortgage, it should be recorded where the searcher for mortgages would be most likely to find it, in the record of mortgages. Section 187. Deed with defeasance is mortgage. So where there was a written defeasance to an absolute deed and the deed was recorded among the absolute deeds, but the defeasance was unrecorded, the two instruments were treated as one, and that one, a mortgage, which not being properly recorded through the negligence of the parties interested, was postponed to the lien of a subsequent judgment. Section 188. Defeasance must be recorded as mortgage. So also where a separate defeasance was recorded, but in the same book with the deed, instead of in the record of mortgages, it was held not to amount to constructive notice to a creditor, for the reason that it would not lie in his way of examining the record for mortgages. Section 189. Parole defeasance, deed recorded as mortgage, and even where there is no written defeasance to the deed, but the contract to reconvey rests entirely in parole, though upon the face it appears an absolute deed, or when the mortgage is so imperfect in form as not to give adequate expression to the intention of the parties, still in either case the intention with which the instrument was drawn, being the true guide to its construction, will govern its registration. If recorded otherwise than as a mortgage, the record loses its character as constructive notice to purchasers or creditors. Section 190. Sheriff's deed recorded as mortgage insufficient. So, where a sheriff's deed was at his instance recorded in the mortgage book instead of the record of absolute deeds, it was held that this error rendered the record void, and if the deed were not properly recorded until after attachment by a creditor, the record could not affect the seizure. Section 191. Record of secret mortgage. There is perhaps a stronger reason for discrediting the record of a secret mortgage because of its being recorded in the wrong book than there would be for drawing the lines with the same strictness in cases where the fault lies entirely with the recording officer. In the one case, the record is misleading because the original instrument is designedly so, while in the other, the honest intentions of the parties have been defeated by the misprision of the public officer over whose acts they could have no control. Section 192 must be filed in proper county. Another important requisite to the validity of the record of an instrument is that it must be deposited for record in the county, town, parish, or other place designated by law for the keeping of such records. Upon this rule, the courts of the different states are almost, if not quite, uniformly agreed. However, much they may disagree as to other details of the registry acts. So where, under the provisions of a statute requiring instruments affecting the title to land to be recorded in the town where the land was situated, though the registry elsewhere might be sufficient to charge those who had actually seen and read the record, it would not suffice to give that constructive notice for which the registry system was designed. Section 193, effect of filing in wrong county. Also, where a new county had been mapped out of another, and the land was situated in the new county, but a grantee, not being advised of the change which had been legally prescribed while the negotiations for the purchase were pending, deposited his deed for record in the old county instead of the new, its registration was held to be worthless as notice to those who were uninformed of the transfer. Section 194, deposit of chattel mortgage in wrong town. So also where mortgages of chattels were required by statute to be recorded in the town where the mortgagor had his domicile, and a mortgage was given by two joint owners of certain articles of personal property who resided in different towns, which mortgage was only recorded in the town in which one of such mortgagors was domiciled. The failure to record in both towns was held to render the mortgage void as against subsequent innocent purchasers. Section 195, change of county subsequent to filing will not affect registry. But where the deed is deposited for record in the office of the recorder of the county in which the land is located at the time, and by a subsequent subdivision, the land falls within the boundaries of another county, such change will not affect the validity of the registration. Section 196, order of priority between deeds. As between unregistered instruments affecting the title to real estate, the order of their priority will be governed by the order of their dates. As between registered instruments, however, they will generally take precedence in the order in which they are recorded. So where there has been a sale of real estate by an insolvent debtor for the purpose of defrauding his creditors, and the fraudulent grantee has conveyed the premises to an innocent purchaser for value, as between the creditors of the innocent debtor and the innocent purchaser from the fraudulent grantee, the law will favor the most vigilant. Section 197, simultaneous mortgages. So also where two mortgages on the same property were simultaneously given with the understanding between the mortgagees and the mortgagor that the two were to take effect as separate and equal encumbrances, and that between them there was to be no priority, and subsequently one of the mortgagees recorded and then transferred his mortgage to a bona fide purchaser who took without notice of the other, and who in his turn transferred the instrument to still another innocent purchaser for value. Before the other mortgage was recorded, it was held that the last purchaser might take advantage of the prior registration of his mortgage. Section 198, as between original parties, priority subject to stipulation. In one case where a mortgage and a judgment against a mortgagor were entered of record on the same day, it was held that prima facie they would be treated as taking effect simultaneously, but a verbal agreement between the parties that the mortgage was to have precedence as notice would be binding upon them, though not upon a bona fide assignee of the judgment. Section 199, registration will not divest accrued rights. Where a purchaser with notice of a prior unregistered conveyance from his grantor had his deed recorded first and then conveyed to another who purchased, without actual notice of the prior conveyance and for a valuable consideration, it was held that if the first conveyance was recorded before his purchase, he would be charged with notice notwithstanding the prior registration of his grantor's deed, and the deed to him would be void. However, had the first mentioned purchaser taken his conveyance in good faith, his prior registry would have given him a perfect title, which would have passed to his grantee notwithstanding the subsequent registration of the prior deed. Where Green v. Deal is reversed for the reason that the assignee of a mortgage is held to be entitled to the protection of the registry laws only with respect to a subsequent transfer of the same mortgage. So, and then it refers ante to section 196. Section 200, innocent purchaser not charged with notice of priorities except by the record. In another case, which seems to conflict with that of Van Rensselaer v. Clark, the land had been mortgaged, and before the mortgage was recorded, the mortgagor conveyed it to another, and for a part of the purchase money took notes secured by a mortgage upon the premises from a purchaser who had actual notice of the first mortgage. This conveyance and the second mortgage were both recorded prior to the first. After the first mortgage was recorded, the notes secured by the second mortgage were transferred by endorsement to several successive purchasers with notice of the rights of prior parties, but the last endorsee had no other constructive notice from the record of the first mortgage. Prior to the assignment of the notes, the second mortgagor conveyed his equity of redemption to a purchaser with notice. The holder of the notes was held to be charged with constructive notice of the first mortgage, but not with notice of the fact that the purchaser from the first mortgagor took with notice of the prior unregistered encumbrance, so that being an innocent holder, he was allowed to foreclose the mortgage by which the notes were secured. Section 201, Order of Filing governs priority. Though it be true that generally a prior deed will be postponed to a subsequent one, taken without notice when the latter is first recorded, yet this is only where the subsequent deed is first deposited for record by the purchaser. For the recording takes effect by relation back to the date of filing for record, and where two instruments affecting the title to the same land adversely to each other are filed for record, and the last filed is first spread upon the records through the negligence or corrupt design of the officer, no advantage will thereby accrue to the grantee in the deed so favored. Section 202. Deed recorded in reasonable time. Where a deed was executed before the property was attached, though the attachment took place 24 hours prior to the registry of the deed, it was held that as the instrument was recorded in a reasonable time, it would take precedence and render the attachment void. Section 203. Subsequent purchaser alone affected. The only purchasers who are charged with the notice by the registration of an instrument affecting the title to land are those who purchase subsequent to the deposit of the instrument with the registering officer. The frequent announcement of the doctrine that the recording of an instrument affecting the title to land was noticed to all the world has at times encouraged the belief that its operation might be so extended as to affect prior as well as subsequent purchasers or mortgagees, and thus control their action with reference to the property in which they claimed an interest. But neither the letter nor the spirit of the recording acts can be supposed to have reference to prior deeds or mortgages already recorded. The effect of recording a conveyance is not intended to be retrospective. The recording of a mortgage is not constructive notice to a prior mortgagee whose mortgage is already recorded, and yet the courts of equity have been asked, for the purpose of granting peculiar relief to subsequent mortgagees, to give such a construction to the statute as would entirely invert the operation of its provisions. The propriety of this construction has been claimed in furtherance of the equitable doctrine that mortgagees, where the same mortgage covers several parcels of land, are required to subject the mortgaged premises to the payment of their demands in the inverse order of their alienation, or, in other words, when a mortgagee, with notice of the equitable rights of subsequent purchasers or encumbrancers, releases one of several parcels of land mortgaged for the same debt, of which the mortgagor still holds the equity of redemption, unencumbered by a subsequent mortgage, being primarily liable for the debt, he will not be permitted to enforce his demand against other parcels, including in his mortgage, which have been conveyed or encumbered subsequent to the first mortgage, without first deducting from his debt the value of the parcels released by him, for the reason that the release would impose an additional burden upon that portion still held. But the recognition of this doctrine does not carry with it the admission of the record of the subsequent encumbrance as a substitute for the actual notice, which would be necessary to affect the conscience of the prior mortgagee and render his act in releasing the portion of the mortgaged premises primarily liable. A fraud upon subsequent purchasers or mortgagees. He is not required to search the record for instruments recorded subsequently to his own, which may affect the title. Section 204, Record of Quit Claim. The record of an instrument is constructive notice of what the record shows, and nothing more. So, where a quit claim deed has been filed for registration and is duly spread upon the records, this amounts to notice simply that the grantor's interest in the land therein described was thereby conveyed to the grantee, and not that the grantor had any title thereto. Section 205. The instrument must be in the chain of title, nor will the putting on record a deed from one who had no record title affect the conscience of a subsequent purchaser of the legal title, nor charge that title with any equities which the deed may have raised between the bargainer or the bargainee. In other words, the record is only constructive notice to those claiming under the same grantor, except in cases where title of such grantor is one which has ripened to perfection from adverse possession. Section 206, same further illustrated. The principle stated above may be further illustrated by a case where the contest was between an attaching creditor and a purchaser, whose deed was recorded prior to the attachment, but the grantor of this purchaser had himself purchased from the debtor of the attaching creditor and had failed to file his deed for record. As a consequence of this omission, the record disclosed no conveyance from the debtor, and it was held that the record of the deed to the last purchaser did not amount to constructive notice of the unrecorded deed to his grantor. Section 207, Effect of Missing Link. So, where the deed from the vendor is not recorded, a deed of trust or mortgage given by his vendee for the purchase of money will not be noticed to subsequent purchasers of the unrecorded deed. There is a break in the chain of title. A necessary link is wanting in order to connect the mortgagor with the title. There is nothing to guide the purchaser beyond the record title of the vendor and the discovery of the mortgage for the purchase money would be purely accidental.